The Compliance Perspectives podcast is sponsored by Athena, automated compliance training, an employee hotline, and case management all in one tool. Welcome to the Compliance Perspectives podcast. I'm Adam Turtletaub from the Society of Corporate Compliance and Ethics and Healthcare Compliance Association. Joining us today from the Netherlands is Lisanne Winde. Lisanne is attorney at law at Winde Advocaten. And also joining us is Alain Lambert, who is Regional Ethics and Compliance Officer for Central Europe for WSP. Today, we're going to be talking about an article that they wrote for Compliance and Ethics Professional magazine about works councils. Alain, Lisanne, it was very helpful to read that article since there's a lot of misunderstanding and mystery on this side of the Atlantic when it comes to works councils. Can you give us an overview of what works councils are?
Thank you for your kind words, Adam. I'm really happy you found the article helpful. Works councils are employee representative bodies within companies elected by the workforce to ensure that the rights and interests of employees are upheld. Now, one misunderstanding we encounter a lot is that works councils are exactly the same as trade unions, which is not true. Trade unions operate at an industry or national level and typically engage in collective bargaining or broader issues like wages and employment conditions. Works councils, on the other hand, operate within individual companies, and they focus primarily on internal matters such as working conditions, company policies, and compliance with labor laws. Since works council members are employees of the company themselves, the dynamic of collaboration is quite different.
Yeah, one argument for establishing the works council is that they bring quite some advantages for the company, such as a much better communication with employees. They provide more legitimacy to company policy. So it's really helpful to have a works council, but in certain jurisdictions, it's not only helpful to have the works council. For medium and large size companies, it's really obliged to have it according to law. And finally, one mystery we hear about from time to time is that the works councils may hinder management or may hinder the compliance programs. But in reality, we see that the works councils are required by law to collaborate with the management and really to improve the workplace conditions and to have the best interests of the company at heart. So ultimately, it's beneficial for both the company and the employees to have the works council and to involve the works council in the decision making.
Lisanne, let me follow up on what you just said. It's interesting to hear talked about the benefits of having works council involved, and also the fact that there are some legal obligations as well. So, when exactly do they need to be involved in decisions in the business?
It really depends on the topic. If the works council should be involved in decisions, it's different for every country, but I think you can summarize it into three different types of involvement. First, there's the information. This includes providing basic legal and financial information. Also, the management is required to provide any information that the Works Council reasonably needs to fulfill its role. There is the consultation, which is goes a bit further than only information. The Works Council must be consulted before a decision is made. And typically this involves significant economic decisions within the company, changes in ownership, termination of employment contract, that kind of decisions. And last, there is the consent. For some company policies, prior consent is needed. This is, for example, for whistleblower policies, disciplinary policies, data protection, and sometimes for secondary labor conditions. And it's crucial that the Works Council is involved at a stage where they can still have sufficient influence on the decision. And this is a bit of a balancing exercise, because if you involve them too early, then the necessary information is not yet available. So then the Works Council cannot really test the decision. They cannot have an opinion about it. And if you involve them too late, the Works Council may no longer be able to influence the decision. So then you don't meet the legal requirements in the process. So in practice, we see it's a bit of a fluid process that can be helpful, in which the Works Council is involved quite early in the process. They are informed that a certain decision is being prepared, and that later on they will be involved as soon as the decision becomes a bit more clearer and they can really have some input on the decision.
So, what about compliance issues specifically? What kinds of compliance program activities must they be included in?
Now, first of all, it's really important to remember that the precise rules for involving works councils may differ per jurisdiction, and in some cases, works councils may have also entered into special agreements with their companies. So it really depends a lot on your specific situation, and you should always double check your own individual case. However, in general terms, the most classical topics where compliance works councils meet are whistleblower policies, employee personal data, and secondary labor conditions. It's obvious why whistleblower policies are important to compliance programs. At the same time, to works councils, most national legislation that covers works councils and that defines their roles and duties expect that whistleblower policies are approved to the last word. At the same time, fortunately, in most EU countries, whistleblower legislation is quite clear about what whistleblower policies must contain and what kind of conditions they should meet. So we see in practice that a lot of the discussions with works councils about whistleblower policies are about topics such as what employees' rights are exactly during investigations or what their duties may be, whether a works council member may be present during interviews, or what kind of protections are in place against retaliation. Another classical topic for these kinds of policies would be what happens with investigation reports after the investigation is concluded. Policies dealing with employee personal data and secondary labor conditions are also important to both compliance and works councils. Personal data is relevant to compliance programs, especially when you're looking at code of conduct training programs, conflict of interest screening, or perhaps even employee due diligence programs if they are present. Secondary labor conditions may be relevant if you're rolling out compliance policies and if you want to do that efficiently, but also in an enforceable manner. In all of those cases, works councils may have a right to be consulted or may even have a veto over rollout of policies. So you would do wise to double check well in advance before taking such actions.
So, what should compliance teams be doing to work most effectively with the Works Council?
It's an excellent question. Works councils tend to differ a lot depending on company culture, the sector, the country they operate in, and of course also the personalities of their individual members. So there isn't really a single one-size-fits-all reply to that question. But let me give it a go anyway. Firstly, compliance officers should just try to get a sense of who they're dealing with. A good stakeholder assessment is always a good idea. Especially in the beginning, I would recommend that you would approach your works council just in listening mode. Try to gauge their priorities, their concerns. That will help a great deal with spotting potential misunderstandings or conflicts between works councils and compliance. In the end, works councils are intended to represent employees, so listening to them also helps a lot with understanding the overall company culture. A second piece of advice would be that it really does help a lot to explain early on what your role is as compliance officer. Works councils are very much aware of their own independence and are proud of that often, but initially they may think of you as just another company manager. So explaining that you too have a particular role and a certain degree of independence goes a very long way in convincing them that you are in the long run also after making employees feel safe and protecting employees and the company from wrongdoing. Then finally, just because you are aware of what works council requirements exist does not mean that all other stakeholders are as well. Especially in complex organizations or multinationals, it's very easy for projects to be initiated far away, potentially at headquarters in another country. Usually it does help a lot explaining in advance that certain decisions may require works council sign-off before the project takes place. That definitely helps with avoiding frustration, both within the Works Council, but also, of course, with all other project stakeholders.
Finally, are there any potential pitfalls that need to be avoided, common mistakes compliance teams make?
Yes, I think the biggest one is something Alain already shortly mentioned. In many multinational corporations, the decision making can be initiated far from the relevant legal entity. And this can result in the Works Council not being included in the process because companies are not always aware that they should involve the Works Council or that the company even has a Works Council. And in the worst case scenario, this may lead to company decisions being challenged and potentially voided, which is not something the company wants, but also not something the Works Council wants. So it's really, for both parties, it's a lose-lose situation. And another potential pitfall, which is kind of related, is involving the Works Council too late. And this can cause significant delays in the decision making and leading to frustration on both sides. Because on the one hand, the Works Council may feel that they're not being taken seriously, they're not involved, while they should be. And on the other hand, you see that management may perceive the Works Council as causing unnecessary delays. And this dynamic between the management and the Works Council can really strain the relationship between them, and not just for the current decision, but also for future collaborations as well. And I think in practice, fostering a good working relationship is crucial to getting the most value out of the co-determination, and ensuring timely and meaningful involvement of the Works Council can really help avoid these pitfalls and build a more collaborative environment.
And in the end, it's much stronger having that collaborative environment. Alain, Lisanne, thank you so much for sharing these insights with us today, both here and in the magazine. I want to thank all of you for taking the time to listen. I'm Adam Turteltaub from SCCE and HCCA. I hope we're able to expand your compliance perspective.